Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
About 8 days ago, my attention has been drawn to a press conference addressed on behalf of the Association of Judges and Magistrates, where some very serious allegations were made. These allegations border on the integrity of the legislative arm of government and cast a slur on the collective image of the Parliament of Ghana. On the 8th of October 2024, I, Sam George, led a coalition of groups made up of clergy, traditional authorities, and CSOs on a family values march aimed at demanding the judiciary, and in particular the Chief Justice of Ghana, to fulfill the promise of an early trial she made in court on the 17th of July 2024. The march was extremely peaceful and adhered to all previously agreed agreements with the Ghana Police Service. The march culminated at the precincts of the Supreme Court. The agreement with the Ghana Police Service was for the leadership to present our petition in front of the statue of martyrs inside the premises of the Supreme Court. However, on the day, the Judicial Service delegation met with us at the main gate of the Supreme Court. We did not protest this change in plan. We complied in the interest of public peace. The Judicial Service delegation was led by a magistrate of the courts, the Registrar of the Supreme Court, the Director of Communications and his deputy, and the Chief Security Officer of the Judicial Service. Our encounter with them was cordial and respectful. The allegations of attempting to visit mayhem on the Supreme Court of Ghana made by a judge of the Supreme Court are very grave and need to be investigated. In that press encounter, several untruths were unfortunately peddled about the Family's Values March by the said judge of the Supreme Court, and it is imperative that the facts are established without any doubt for the benefit of the public. As such, I will be invoking the jurisdiction of the Privileges Committee of Parliament to summon the gentleman who is a judge of the Supreme Court to the Privileges Committee of Parliament. He addressed the said press conference, and he needs to substantiate a number of untruthful claims he made in his press conference. The image of the Parliament of Ghana must be respected by all persons, and especially by those who are in a privileged position and ought to know better, and must be held to higher standards of accountability. At this juncture, let me reiterate that at no point in our petition to the Chief Justice did we demand, request, or even remotely suggest that the Chief Justice should rule in favor of the sponsors of the bill. We have simply asked for the Chief Justice to provide us a timetable for the early trial she promised. Our petition is premised on the actions of the Chief Justice in 2 cases this year, where the court swiftly issued hearing notices within hours of injunction applications being filed, and heard the cases even without a statement of defense from the respondent, the Attorney General in particular. In the Roxinda Fiamekpo versus Attorney General case, the Attorney General did not even file a response, but the Chief Justice heard the injunction application and dismissed the injunction application within 24 hours. Again, in the Bernard Ahia 4 and 2 others versus the Minister for Finance and 3 others case, the injunction application to hold certain tax waivers by government pending determination of the main case was filed on Friday afternoon, 26th of July 2024. By the following Monday, the court had issued hearing notices, heard the case and dismissed the application the next day. This was in spite of the court's own rule attached to the process by the registrar, stating that, and I quote, "A date will be fixed for hearing of the above stated application with hearing notices to the parties by the registrar upon request 20 days after service of the application on the respondent or interested parties," end of quote. In fact, lawyers for the plaintiffs in that case were compelled to argue their case on the same day. This raises fundamental questions of what the real intent is in the current cases regarding LGBTQ and the lethargy we are witnessing from the Chief Justice and her court. Again, let me state for the record that it is a complete untruth and palpable falsehoods peddled by a justice of the Supreme Court who addressed the media for anyone to claim that the injunction cases before the Supreme Court is not ripe for judgment. All pleadings and arguments have been made before the Supreme Court, and the Chief Justice scheduled 17th of July 2024 for her ruling. How will the CJ have scheduled a date for ruling if the cases were not ripe? Persons who ought to know better should not be engaged in peddling of factual untruths which are easily verifiable. Our judiciary must always remain above reproach. As sponsors and as members of the coalition who embarked on the Family Values March, our position remains unshaken. The Supreme Court panel, hearing the Richard Delaskai and Amanda Odoi cases, led by the Chief Justice, must be minded of the ruling of the Supreme Court in the Dr. Prince Obri-Crying versus Attorney General case, delivered on 24th July 2024. Their lordships, Bafoboni JSE presiding, Lovelace Johnson Mrs. JSE, Amadou JSE, Kulendi JSE, Jehu JSE, Dako Asari JSE, and Ajay Frimpong JSE were emphatic on the position of our law and constitution on homosexuality in their 59-page ruling. Let me quote their conclusion in that ruling. I quote, "In conclusion, I wish to reiterate, in respect of the issue that was set down for determination in this suit, that Section 104.1 of Act 29, which criminalizes non-natural carnal knowledge, does not contravene the Constitution of the Republic of Ghana. The plaintiff's conception of private morality as a ground to limit or expand the constitutional rights to privacy lacks sufficient context in the nation's constitutional architecture. Indeed, it is fundamentally poles apart from Ghanaian family values. Our constitutional provisions derive their purpose and values from our traditions, customs, and culture. Consequently, the plaintiff's action fails in its entirety." End of quote. And this is the conclusion of the 59-page judgment from the same Supreme Court of Ghana. We insist that the court, led by the Chief Justice as head of the judiciary, can, and in similar manner, which it swiftly dealt with applications referred to, control these cases so such important law with overwhelming approval by Ghanaians is assented to by the President. Once again, let me reiterate my decision to invoke the Privileges Committee, the jurisdiction of the Privileges Committee of Parliament, and bring before the committee the judge of the Supreme Court to substantiate his allegations that I led a group to cause mayhem at the Supreme Court. Persons who ought to know better need to act better and will be held to higher standards of accountability. At this juncture, I will play a video that shows my encounter with the Judicial Service. I'll be serving you the raw copy of that video as well to establish for you that the claims made by the judge of the Supreme Court, who also doubles as the president of the Association of Judges and Magistrates, were nothing but calculated lies and falsehoods aimed at tarnishing my reputation, the reputation of members of the clergy, and by extension, the reputation of the Parliament of Ghana. We will defend our reputation. with our last blood. Thank you.
Your statement, the Supreme Court made reference to having, and I quote, an early trial, assuring us that they will work expeditiously to hear and rule on these matters in a timely manner. Unfortunately, over 10 weeks later, there is no indication of any schedule or actions to execute an early trial that will protect our rights as citizens to timely and efficient justice delivery in this instance. Without speedy scheduling of the hearings, further time will be lost, potentially preventing the conclusion of the bill this year, and further risking 3 years of time and resource investments in this draft bill, and precipitating the need for more time and investments in this bill is to see the light of day. This will result in significant financial cost to all stakeholders, including the citizen and state. Overall, such an outcome will undermine the legitimate hopes and aspirations of over 90% of Ghanaians to obtain.
A judge of the Supreme Court would make allegations, and I will share that video as well with you, that I led a mob to visit mayhem on the Supreme Court and hurl insults on the person of the Chief Justice. It's unacceptable. You have heard the tape. I will rest here. The rest will continue before the Privileges Committee of Parliament. Thank you. There's established precedents in this House that what you need is quorum for a committee to meet. If the committee has quorum, whether the chair of the committee is present or not, members present can appoint a member to preside. And once the committee has quorum, it will be a properly constituted committee of the House. They will proceed and do their job. I will be sending my petition to them at the beginning of next week, and I will be demanding an expeditious invitation and hearing of the Privileges Committee. If the MPP caucus, which is currently the minority caucus, choose to boycott that sitting, it will be up to them. But I would pursue the protection of my integrity and my image, and by extension, the integrity and image of Parliament. Because when the judge kept making the allegations, he kept saying a member of Parliament. He should come and substantiate which member of Parliament. Yes, sir.
Thank you, sir.
This is unbecoming of any member of Parliament, and we would want for him to establish who that member of Parliament is, establish the visiting of mayhem, and then ask for the Privileges Committee of Parliament to ask Parliament to sanction that MP. Because that MP's actions have brought Parliament into public opprobrium and reduced the standing of Parliament in the eye of the public. But if that is not the case, then it will be up to the Privileges Committee to determine what to do to whoever it is appearing before the Privileges Committee who has made such allegations. So this is not a matter of constitutional interpretation. This is not a matter of any contest. We've seen the judiciary, which is one arm of government, issue contempt hearings against members of the executive. The director of BNI, the IGP are all members of the executive. They are officers of the executive arm of government. And we've seen several times contempt cases being filed against them, or even arrest warrants being filed against the director of BNI or NIB as it is called. It's within their rights. The courts have their rights to exercise their function, and so also does Parliament. There is no exemption to who the Parliament of Ghana can summon before its privileges. There are no exemptions given. And so once no exemptions are given, no exemptions will be expected. Just a judge of the Supreme Court, which in itself is a very noble position that we expect people of high moral standing to occupy. That's what the Constitution says. And then he doubles as the president of the Association of Judges and Magistrates. He speaks barely 24 hours after I have led a march to the Supreme Court. He claims that I have brought a mob to visit mayhem. He claims that I have made demands of the Supreme Court, demands that are not included in my petition. You've listened to the tape. Demands, claims that I'm asking for rulings to be made in my favor. Claims that I have held insults at the passing of the Chief Justice. You heard the tape. I don't sit here. If it was just me and Sam George, that's fine. If he had just said, oh, Sam George, but he said a member of Parliament. The people of Ningo Pram Pram who elected me need to be sure that their member of Parliament is not acting in a way that reduces Parliament. And so I think that this affects the whole image of Parliament. It will be up to Parliament to say that, oh, it's fine for judges to peddle untruths about Parliament and Parliament will not care. But then that will be setting a precedent. Tomorrow, we've had people invited before the Privileges Committee for saying that some MPs smoke weed. He didn't mention any one person, but he was asked to come and substantiate which MPs he was referring to. Because we thought that that was a blanket statement about all members of Parliament. So if someone says a member of Parliament, you should come and establish which member of Parliament. I think that's within our rights to establish that.
So good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.